think there actually might be a box of them in that corner. Sorry. Okay. Perfect. Yeah. All right. Thank you everyone for attending. I just want to let you know that this meeting is being recorded just so we can reference it after the fact. It will be available on our YouTube channel and on our website if anyone has anything that they want to reference with it. My name is Melissa. I am the communications director here. I appreciate everyone coming out, and this is our fabulous attorney partner, Nancy Harrison, who is our family law expert that will be speaking today, and you can ask her any questions that you feel comfortable with regarding certain family law matters. So Nancy,
All right,
and kick it off.
thank you.
Melissa or Melissa.
Thank you.
You're very welcome.
So I am Nancy Harrison. I am an attorney, and we are here today in conjunction with St. Johns County Clerk's Office and the St. Johns County Legal Aid Office. And just so you know, most of you are here because you're going to represent yourself without question, without using an attorney. So everyone knows St. Johns County Legal Aid once a month has what's called a pro se class. You can contact them. Really what we're there to do is to help you fill out all these forms that can be quite confusing and you're not sure exactly what to put in them. We help do that once a month. It used to be live, and then after COVID, we've kind of done them by phone, or if I'm doing one, I can do it by Zoom or however, so that we can get your forms in good shape and you can bring them here and file them. Okay. There are some flyers here that have all the information about those pro se classes, so that you can pick those up on your way out. So last week we kind of did a general overview of family law cases. So today I'm going to focus a little bit on what, in a family law case, what are the steps? What do you need to do? What the court can do? If you need help from the court, how to get it? What you are not supposed to do.
Right.
What the judge can do, what the judge cannot do for you. Just a lot of information like that. Clothing attire for the courtroom. Communicating with the judicial assistants, those are the judge's assistants. And how you go about that, and who you need to copy on those things. Okay. So you don't get in trouble and the judge is not fussing at you. We'll go down that road. We'll also look at our standing family law court order, which comes into play in every single family law case, so that you know what your responsibilities are in a family law case, and don't get in trouble for that, because that's court order, you could be held. So we don't want that to happen. Okay. All right. So a few things that you need to know beforehand. The clerk's office can provide you with some forms. You can also go to flcourts.org and print out whatever you need. All those forms under the family law self-help have instructions. They also tell you what other forms you have to buy, because there's a lot of them. So the instructions are pretty good. They're all in layman's terms, so they're not speaking in lawyer's tongue, which can be confusing sometimes, so that you can walk through this. The clerk's office cannot give you legal advice, and I get that's frustrating sometimes. Come here, you have forms, you don't just need help filling those out, you want some legal advice. You're not going to get it. Okay. Pro se classes are great for that. We can give you some legal advice. I always suggest at a minimum, if you can't afford an attorney, is have a consult with them. There are attorneys out there that give free consults, and they can give you some information, and they can give you some legal. So try that. Just so you know, if you decide to represent yourself, you are held to the same standards that I am. You are to be familiar with Florida rules of civil procedure, the family law rules of procedure, the law on whatever issue you're asking the court to address. and evidence codes. And that gets complicated, but we'll talk a little bit about that. If I were to have a session on that, we'd be here for 3 weeks. It's a difficult subject, but I'll give you some basic information. And how do you get your evidence into the court so it's admissible? We'll talk a little bit about that. Let's see. To begin with, if you file a petition or a motion, you do not have a pending case. You have to have the other side served. The clerks will help you with that. If you're filling out an indigent form and get approved for that, you won't have to pay a filing fee. You won't have to pay for service if it's here in St. Johns County. They'll take it over, or you can walk it over to the sheriff's office and they will serve it.
I have a question about the indigency. So, because I've already seen it online. So do they give you a bill at the end of the year? When do they actually? Because they're just postponed, you know, I know that. So how does that work?
Postponed. You're indigent, you're indigent.
Because
You
it
get
shows on my thing, on the courthouse website, it said, $50, $60. So, because when I
If you get
filed, it
approved
said
for
it's like postponed. That's what I read on there.
They
just get waived.
Yeah, they're.
Okay, I was just wondering, because that was on the website.
Yeah, I've never heard of that.
So where do you have somebody served?
In your forms, you're gonna see a summons.
Okay.
You fill out the summons. It'll ask what you're serving. So if you're serving a petition for dissolution of marriage, you need to write that in. And then if they're in St. Johns County, you take it over to the sheriff's office, just across the street,
Mm-hmm.
and they'll serve it. You hand it to them.
What if you don't know the person is?
That's a problem.
Yeah.
So there is something called due diligence, but it's a lot. But you need to do the best you can to find out an address. To find out, sometimes you can call your utility company and ask about them. Sometimes they'll tell you get a nice person, sometimes they won't. If they've been in the military, you can write DFAS and ask them if they know where they are. There's ways to do that. If you come through that due diligence search and you can't find them, you can serve them by publication. And that's a whole process. So I'm not even sure that's online.
If the person lives in a different county, then can you file in your county or you have to go to your county?
It depends on what you're trying to do. So if you're getting a divorce here, then you can file here if you live here. It also depends on the last place you lived together as husband and wife. If you're still living in the same house, then clearly you would file here, and that happens a lot. You can file here even if they're in Duval County, but that comes down to a jurisdiction and a venue issue. So jurisdiction in St. Johns County, if this is where you lived, you've been here for 6 months and you need a divorce, you can file here.
Maybe had one.
If you
You can serve them. You can serve them out of this county. You can also serve them out of the state. But that is another issue. And with that, we'll take that up on
Is
another day.
The idea though is to serve them where they live, like, publish where they live if you can't find them, right? So-
No, you publish in the county you file in.
Oh, I publish in county, I file in.
Would that be like in the slides or how?
Well, in Duval County, I know we have something called the Daily Record, which is actually a legal newspaper.
Yeah.
I mean, most people who serve by publication never know. I know that sounds silly, but you have to give the notice out there to them.
Would you try to serve at the last known address?
You can try that. If they work, you can try to serve them there. If they're in jail, that's easy.
I wish.
Yeah.
With my situation.
What if it's down to like child custody, what's considered abandoned?
As far as
The,
a family law case or a dependency type case?
for the custody case of a child, a minor,
Uh-huh.
if one of the parents, left for like a year, and then they come back, and then they want joint custody.
Is there already a court order in place?
Yes, they've gone, they weren't prepared. It's my daughter and her husband, but they weren't prepared. You know, when they filed and all that, and then when it came to the custody hearing, there wasn't enough time
So there
to
isn't a
pay
court
for
order.
everything, so they're gonna come back to them and give them notice.
So we'll get to the standing family law court order, but as long as there's two parents involved, whether they've left and come back, you have to encourage a relationship. If there's no violence type issues, you need to encourage time sharing.
So what happens if the child doesn't want to go?
They don't pay the state.
Unless they're
They're
17,
They're 12 and
Probably.
yeah,
no.
To encourage a relationship.
You have to encourage, I mean, my kid at 12 was almost 6 foot tall. Could I get him in a car and make him go somewhere? No, but you have to do what you can to get them.
Even if the other parent is like a biggest loser on the planet.
Yep, yeah,
Yeah,
you
Sorry.
make a baby with them,
well, I didn't,
that's
but.
what I'm saying,
Yeah,
you know?
yeah.
Nancy, just want to throw something out there. I'm so sorry to interrupt. For anyone that is tuning in virtually, if you have a question, please use the hand raising icon at the top of the screen so we can call on you, or you can type it in the chat. Go ahead, sorry.
That's all right.
Just want to make sure.
So if you have a court order in place already for custody and time sharing, if you do, I'm just saying for everybody else, if you have one, you have to follow that court order unless there's some emergency and the court has already entered another order, a domestic violence injunction, you have to follow it. You have to file a supplemental petition to change that custody situation. Until there's a court order, you have to follow that to the best of your ability. Or the court can hold you in contempt. They could give the other parent makeup time sharing. There's a lot of punishment to that, so you don't want to really get in that scenario. Do you have to make a kid? If they're young enough, you need to make them the best you can.
Do you want to even accept a phone call from him, you know?
Then the parent should be taking the phone call and giving it to the child.
Well, she has her own phone.
Doesn't matter. That's the encouraging a relationship. And as parents, we have to do that.
So a question I have is, I'm going to be filing an injunction for my thing, 'cause it's going to criminal. So on what you said regarding that, so it is an emergency situation. So therefore I am filing an injunction. So, I mean, what is the likelihood that, I know it's a, draw them out of a hat, who gets this injunction this day? What is the likelihood based on it being criminal with the children that they'll go ahead and approve that?
Criminal as someone's already been charged criminally.
They won't arrest him. They want to do their little procedural thing, and I've already told them I'm pressing charges and.
Well, what the court's gonna look at, and if I had a petition in front of me, they're gonna look at past behavior. Okay, have these things happened before? Is this person, destroyed property? Is this person taken cell phones and destroyed them? Have they held you and not allowed you to leave places? The violence, I mean, there's a whole list of things. Have they killed animals before? Have they had other injunctions against them?
Yeah.
All that matters, but what it comes down to is when you get in court, you have to present the evidence about what has happened. And then the court has to decide, is it reasonable to think that there is going to be imminent danger to the petitioner, the children, whoever you file on behalf of? And that's what they do, and they follow the law. I know people don't like the decision sometimes, but if it's a iffy situation, you may not get the injunction. Now, here's what I tell my clients. If there's a violence issue and there's a time sharing order and the kids are in their care, will they be in contempt if they withhold those children? Yes. But you do what's right in the best interest of your kids.
That's what I'm saying.
And then you can explain it to the judge. I mean,
Another,
that's the way I look at it. I would protect my children no matter what.
so I had one quick question too. So I've also requested a different judge. Do I have to file a hearing a court order for that to be brought to the court?
And you have to file a motion to recuse the judge.
See, they wouldn't give me that here. I asked for the specific thing.
Well, there's no form.
Motion to disqualify, they didn't have that. So
Yeah,
they just
you-
made me do plain pro se form.
Yeah,
So I just
I mean,
don't know if they'll accept it.
there is not a form for everything. So
What did you call it?
a motion to recuse or disqualify.
Okay, that's it.
Um, but unless you have a legal basis, that's not gonna happen. Okay. The judge decides if they recuse themselves.
I hope so. Still the worst from everyone in this county. They'll tell you if they went for him.
What about in the case when it's abandonment, like active addiction? Can I get?
For withholding the child. You could be, technically, you're in contempt if you're withholding a child. You
Well,
are.
if he like abandoned and like I can show a long history of addiction, like.
The thing about if you're in that scenario and there's nothing pending in the court, file something.
Okay.
Okay, you need to file something. You need to let the court know you've got a problem. You might even put in there, I'm withholding the child for the child's protection.
Would I do that, because there's already an agreement in place, I'm just trying to modify, would I file an injunction, can I file an injunction?
It depends on what the scenario. Well, it depends on what the scenario is. If you already have a court order for time sharing, you file a supplemental petition
Yes, yeah,
or modification.
okay.
The supplemental.
Petition for modification.
I have a question pertaining kind of on the back of what they were asking. So if the father pretty much has abandoned the child and hasn't been involved in drugs and all that stuff, does he have to come to court to get rights? Or does he automatically have rights?
Well, fathers in Florida and husbands of children have rights.
Yeah.
And they did. There was a time that the mother had more rights than the father, but the laws changed slightly on that.
Yeah.
So, but if there's a court case pending and there's a hearing or a case management conference, everybody better show up.
What if he just doesn't?
Then you tell the court's gonna know he's not there. And, you know, you could ask for a default if he didn't answer, whatever you file,
Mhm.
or get the court to set a hearing.
Set a hearing to take away his rights for not. showing up.
Whatever, you're not gonna get someone to take away their rights in particular
Yeah.
unless it's really bad. That is a petition to terminate someone's parental rights, and that's a steep burden. Very, very heavy burden.
Yeah.
Because Florida, you know, they want kids to have two parents.
Once I file this, will I have any standing or I have to wait till everything goes to court?
Standing.
Like, would I guess not be held in contempt because I'm in the process of getting custody or?
And there's no court order right now?
There is,
Oh, that's right, you're-
Share, yeah.
Let's put this. So Judge McGillen, if you've ever been in his courtroom during case management, he has this slideshow that he shows, that is about really the standing family law court order. I mean, he's telling you the protocol, and I call those cattle calls. Everybody shows up and you wait your turn. So it takes a little time, but now they're showing you where you stand. If you have an attorney, they'll direct you to the right place, or the bailiffs will direct you. Just going, behave yourself and try and get your case resolved if you can. So in your case management, here's the chance you get to set court hearing. So if you have a motion pending or you have a supplemental petition, you can ask about that. It depends on how quickly it's been. So if you filed it today, they're served in 20 days. They filed an answer and then you have a case management. There's something called discovery that needs to occur, but once that has, the court is going to refer you to mediation, which you'll go to. Every family law case goes to mediation so that you can try and make a decision about your family. And if not, you're gonna have several case management conferences. Ask the judge to set it up for a hearing if it's a motion, whatever you need, but he's the person. There's clerks that are in there with him. His judicial assistant may be in there and she's got his count. So they may set it right there and you'll know the date and time. But that's important. You have all these documents out there that have been served, they're pending in the court. You need to have a hearing if it's a motion. You need to set trials if you have petitions out there. So case managements are very important. This is what I'm talking about. If people don't show up, the court could dismiss a case, find someone in default, give you what you asked for in your petition. But you have to really kind of ask for that. And the judge may deny it the first time. Give them a chance to come back. Parental rights are constitutional. So if somebody takes away your parental rights, just because you didn't show up to a case management one time, that's severe. That is beyond our constitution. and,
Yeah,
uh,
right. So,
Unconstitutional.
I'll take up everybody's time with my specific thing, but can I just tell you real quick?
I don't want to know facts. I'm gonna ask general, we're gonna ask general questions.
Okay.
We can talk afterwards if you want, but everybody's case is different. Everybody's
yeah.
facts are different. So I'm giving you very general advice today.
Yeah,
You know, and I understand kids get in situations they shouldn't be in and you, as a parent, are trying to protect them.
yeah.
I understand.
And Nancy, would you follow this same procedure if it's like for visitation? Visitation is.
That's part of a parenting plan. If somebody has a parenting plan in place or you want to modify it, that's part of what you can modify. Is that parenting plan, time sharing, parental responsibility.
What about just enforcing?
That's a motion to enforce or a motion for contempt. Depends on what they've done, whether they can be held in contempt or just enforce something. I can tell you, most attorneys make them more motions for contempt and enforcement. They show up like they don't know what can be, somebody can be held in contempt, but that way you've got an option, especially as president.
Back to your county thing. If we live in Nassau and the other party lives in Ocala, I think it's Marion County, does that party have to travel to Nassau for any hearings?
Today, a lot of judges allow Zoom hearings. That person could file a motion for requesting that. If the judge says no, they have to.
Okay, that's a big question.
Okay, all right. Talk about the service, you have to do that. Now, on all your documents, you'll see on the back page where you sign, there's also what we call kind of a certificate of service. Every document you file with this court has to have a certificate of service. What it says is, I have provided a copy of this to the other side. So you're swearing that you did it. You drop it in the mail. Quite honestly, if you're representing yourself, you need to set up a username and password for the e-filing portal. It makes life easier. You can go in there and look at your case like that and file things. If you can scan it into a computer, you can file it on there.
I have a question about that. So they want you to know all kinds of submission numbers and all that just to do it the first time. Cause I've watched the instructional videos on e-filing and all that. And some of those numbers you can't get from the courthouse website. So how do you even do that?
What do you mean?
Because it says like submission number. Okay, they may or may not have had that when I tried to do it. But then they ask for some type of other number that attorneys usually get for you to just file on there the first time. Anyway,
Well, did you set up an account?
yeah,
Okay.
set up an account.
So
They make it really impossible.
I don't do them very often, but I do file things from time to time. I think I've done it right then. So you put in what county you're filing this in. And then there's a process that should walk you through each page. So put in a case number. If you have,
It doesn't even find me. We have millions of documents at this warehouse. It doesn't even find me at all.
you have case numbers,
Okay.
better check to make sure you're putting them in right.
I've been memorizing up here 3 years ago, of course. So,
But it doesn't
it doesn't find us. So it doesn't make it easy for us pro se people. It was designed for attorneys, I'm guessing that's why.
I don't know, it's pretty complicated. I've got a long time.
Video, I know, you'd think it'd be easier.
Yeah, I'm just trying to walk through. But I understand that, and I don't know if the clerk thinks with that or not.
If I may, just interrupt here. So the case styles, it's very funky. So it's external to us, it's external to the judges. That system, it's run by the state. So we always encourage pro se people, it's tough to navigate. Bring us in the paperwork. It's an inconvenience to come in person, but we're happy to process it right there on the spot for you versus having to deal with uploading all those digital files with the possibility of it getting rejected.
And that's legal aid, right?
I'm sorry.
And your legal aid, is that?
No, ma'am, I'm with the clerk's office. So myself and Melissa here and the family law supervisor, we're all with the clerk's office.
Oh,
It can be complicated. I can tell you, I've got lots of stuff. And when you do that, if you're bringing hard paper here, keep a copy for yourself, okay? Always make a copy to keep for yourself. One, so you know what you got. And you have a copy when you go to court, so you know exactly what you've done. If you've been served with a petition, you need to file an answer within 20 days. That's very important. If you don't file, the court could enter a default against you. And what that means is essentially what the other person has asked for. You've admitted to all those allegations, and the court could give it to them.
Say that again.
So if I file a petition against my husband for a dissolution of marriage, and I ask for the sun and the moon, and my husband doesn't answer within the 20 days, we go to a case management, he doesn't show up there, I can ask the court to give me everything I asked for. Now, if there's children involved, there's gonna be a hearing, because that's, again, our parental rights, but, you know, you gotta participate in a lawsuit. So if you get served with a motion, you can file a response, but you don't have to. Okay, it's not necessary. But a petition, complaint, all those things, you need to. Domestic violence is different, you don't have to file a response, because it happens quick. It's really quick. They're supposed to have a hearing within 15 days. So don't forget that part, you need to do it. Now, if you need to communicate with the judge's office, to the judicial assistant, do not communicate with them without copying the other side. That's called ex parte communication. It is not allowed by you, nor by me. Period. So if you don't get a response from the judicial assistant and you didn't copy the other side, that may be why. The judge is not even supposed to read anything. So, you send a letter to the judge and you didn't copy the other side. They may file it in the court record, but he will never see it.
Question with that. So I've only experienced calling the judicial assistant person. So how does it work as far as, because I know you have to call their assistant to set a hearing and that sort of thing.
So you can call the judicial assistant, but you better have a phone number. If you don't know how to conference someone in yourself, give it to the judicial assistant so she can conference them. Okay. They don't want to talk to you. It's inappropriate even on attorneys. You just can't do that. Okay. So I tell my clients this sometimes. If you're filing a lawsuit, make sure you're ready for whatever the other side's gonna. If you're filing a supplemental petition, he may do the same thing. You both are worms. I tell people sometimes, sometimes I have people who come in who have a child support order through the Department of Revenue. And they need something else. They need sharing, whatever it is. You've opened the door to lots of things. And the other side can start asking for their own requests. So child support, Department of Revenue, they deal with just child support. They can do paternity and determine paternity, but they cannot provide timeshare. So I warn you, if if you file something, the other side may file the same kind of thing and be ready for that.
What
He's
if-
open a can of worms.
What if, the father isn't paying child support, or has never paid child support? Does that have any, is that,
Is there a court order for child support?
No.
If you need to, I don't know why there isn't. It should have been done at the time of the order. Get back in front of the court.
We have a question from.
Yeah.
Virtually, right here. With the ex parte, if the doc is e-filed with service to the other side, but without a set hearing, is that still inappropriate? Court won't look at it despite being in the court record.
No, if you file something in the court can look at it. I'm talking about direct communication with the judicial assistant. If you're communicating them for anything, to set a hearing, you need to copy the other side. They are just as entitled to hear your communication with the JA than you are. So it doesn't have anything with what you file with the court. That's a different scenario. They're gonna get served with that, even if it's through the portal or you mail it to them with your certificate of service. That's different.
So I'm basically your situation where I filed those with child support and modification way back, don't know why they haven't served them yet. And then here, so as far as their side, because I've already called them and they don't really know anything when you call them. They're just like, well, we just deal with the money part. So what I'm trying to do is I'm trying to make the thing I had to do here and with them look exactly the same, but.
The Department of Revenue.
So I'm like, you know, I'm wondering, I mean, from your standpoint, what is best to pursue more with the courthouse or with them to get the thing?
Well, the Department of Revenue is free. Let's start there. Okay. And if you're seeking the child support, there is an attorney that's representing you. It probably doesn't feel that way, but they do represent you. Why they're not doing anything, I don't know. Maybe they can't find it. I don't know where
I'm
it's
just gonna
at.
get all my stuff first because they're dragging their feet, so.
And if you have an address, get in touch with them. Tell them what it is. That may be the problem. All right, let's see. Talked about the failure to appear. Can we pull that back up to get to the standing family law court order?
Oh, boy.
It's got the evidence in it.
This one?
Yeah.
Oh, wow.
All right. So the standing family law court order is, it is a court order. Every family law case. If you violate it, you could be held in contempt. So what it really addresses is on a financial level, you really have to maintain a status quo. So let's say you're married, you know, your husband's the breadwinner. He typically pays most of the bills, but you're paying an electric bill and a phone bill, those kind of things. You have to keep doing that. If you need help from the court, you need to file a motion with the court. If you have life insurance, you must leave it in place. You must leave in who the beneficiary is at the time. If there's health insurance involved, you can't cancel that. You know, that's, some people are vengeful and they want to do that, but they will get in trouble for it. The standing family law court orders, read them carefully. They talk about children. They talk about encouraging these relationships. They talk about communication with the other parent. You know, I know that's hard to do sometimes. You don't get along, but this isn't about you. This is about your kids. So try to tuck that away, all that anger, and have a conversation about your child, your children.
Nancy, if one of the parents was messed up in drugs and went to jail and all his calls to the ex were refused and she didn't allow him to talk, is that contempt of court also?
Is he calling from jail?
And I paid for the calls. She didn't have to pay for anything.
Yeah, I would say it is.
Okay.
Now, I would tell you, if I was her, I would monitor those phone calls. If
Moving
he's in
forward
jail
with
for
the rest, with the children would also be a contempt of court.
Say that again.
Moving without living, giving a forwarding address.
Well, if you have a case pending, you're supposed to notify the court of a change of address. And you need to do that because you may not get notice of things.
What happens if the other party never did it, but you went ahead and did it? Is there any way thing you can do with the court?
Change of
Because
address.
he never updated the court, he's new. So,
Well, and if he shows up at a case management, bring it up.
okay.
Because there's a form for that. I was just in case management last week and Jay actually gave this person a form. So they'll help to the extent that they can do that because court needs to know whether. All right, here's some rules about court. Do not bring any children to court. Ever, unless there's a court order that says you can do that. If you want a child to testify, you have to file a motion with the court. They make that decision. Because you have to remember, if your child doesn't testify, if they allow one in front of you or attorneys, it's a private conversation with the judge. So they're not influenced in any way. But no matter what, that's a traumatic experience for a child. Unless they've lived through some trauma, they really want to tell the court. Okay, so be careful with that. I try not to involve children. They will never forget it. I know an attorney who had to testify in her parents' divorce, and she's 65 years old. She will never forget.
Guys in the car.
Of
Jeez.
the parent,
Yeah, like when my child, like tell anything.
that's hearsay.
So what if they illegally did a video of you without your consent? Can that be used in court?
What kind of video? Where was the phone?
He put me in his pocket and he moved it every time I went to talk so they couldn't hear my
And
mouth.
where were you?
I was in the room with the infant breastfeeding. He didn't have my consent. I discovered it later.
Technically, the law is you can't record phone calls.
So that's admissible then.
Good thing. Be careful what you say.
And then what about as far as, a recorded phone call?
Yes, that is a crime. Now, if you leave a voicemail, sure, it can come. Now, do judges like it when people record? Especially if they
Depends
can
on
see
who
it
they are.
and the children can see it? No, they don't.
I've seen some scary things that are illegal that they did in this courthouse.
But if they're recording something, they have a reason. So just be careful of your own behavior because it'll come up. Okay,
How do you submit those though? for the court?
that is
Here.
an evidentiary issue. And if you're taking evidence, first of all, you need 3 copies. So even if it's a recording, you need to get it on something that you can give a copy to the court, give a copy to the opposing party, and you have a copy yourself. Always. If you don't bring that, it's not coming in. Because the other side has a right to see it, hear it, whatever it is. Typically, if you're in trial, they're gonna have that before you ever get to court.
I'm surprised he didn't use it actually. His attorney probably said no because it was illegally done. So
That may be, or it may not have benefited him like he thought it would.
What if there's an older child that is 20, almost 21, and then a younger child that's 12 and a half? And the older child at 17 wrote the father a letter and told him he didn't want anything to do with him because he was flawed and he needed help.
The letter is not admissible.
Okay.
It is hearsay. Hearsay is an out of court statement. So you're not in court. Someone said something out of court and you are offering it to the court to prove the truth of whatever was said. The only exception that happens a lot in family law cases is if my husband says something to me, I can tell the court what he said. He can tell the court what I said. Because we're parties, they consider that an admission, which is an exception to hearsay. And there are like, I don't know, 30 exceptions to hearsay. That's what I said. It's a lot of work to go through all that.
What if the other party like denies the truth of what they're saying?
It's a he said, she said that.
And so then it just becomes a,
Well, and a lot of times, text messages between parties, those are communications. They just happen to be written.
are those admissible?
Mhm.
Or text messages?
They are if you lay the proper foundation. That they're yours and they're opposing parties' text messages.
Do you have to provide 3 copies?
Absolutely. Everything you bring to court that you want the court to look at and consider, you need 3 copies. Absolutely.
So, I mean, is there like a form you fill out that, so that they're aware that you're bringing them to court?
So if you have a trial, there in your pretrial order that sets your case for a trial, it will tell you exactly how you get your exhibits to this courthouse, and it's usually at least 4 days ahead, I believe.
It's 3.
And then the other side gets them at the same time, and you will get the same from them. So you will know what the exhibits are beforehand. Okay, so you could do some research then
Okay.
and get down to your hearsay, what is hearsay, what's not. I mean, even medical records, unless you have the appropriate backup document to lay the foundation, that's hearsay. That you are offering it to court for the truth of what it is. So evidence is a big deal, and I know that's difficult. Some attorneys struggle with it.
Can you submit for someone like that? If I were to try to prove my case.
So that's part of the discovery process. It's called a notice of intent to serve a subpoena to a non-party, because they're not a party. And then you need the subpoena. You need to put in the subpoena what documents you're looking for. And you would also want a records custodian affidavit. Tell you how this works. So you file your notice of intent and your subpoena as one document in the court record. And then you have to wait 10 days. If the other party objects, you cannot send your subpoena. If they object to it, they'll file a written objection.
Question.
If they don't object, you can send it out, and sometimes you need to call them and see if they'll accept service. Some people, you can mail it to them, you could fax it, you could email it. Otherwise, you're gonna have to have a sheriff serve it. And then you'll get your records. The records custodian, that is the person who's giving you the records, that says, these are the records I certify that we keep on the regular course of business, and they are what they are essentially. Then you may be able to get the hearsay in. There's a process for that too, but at least you have the records custodian that says they are what they are. It would then become an exception.
And that's through the courts, right? The records custodian is through the courts. That's,
To whoever you're sending the subpoena to.
so it would be like to his medical.
Right, now, if you're asking for medical records, you may need an authorization of the patient, so may not give them to you if you're looking for medical records. If it's your child, you know, you can get them, you can probably walk in to your own pediatrician and have them hand them to you. You don't need a subpoena for
It would
that.
be like
It's your
for
child.
that. It would be for their.
And that may be difficult to do.
I had a question.
It's a HIPAA violation as well.
I know, are you saying just for pro se's that they shut it down, you can't do the next step that an attorney is supposed to do that mine in the past didn't do?
What are you talking about? What's the
Well, they
next step?
shot down the getting his medical records to prove his condition. Well, my attorney, come to find out, could have pushed further in order to get that, whatever that filing is, and he didn't do it.
Yeah, somebody objects,
Yeah.
you can call that objection up for a hearing. Because if it's an issue in the case, like drug use and that kind of thing, you could probably talk the judge into letting you have it. But if it's not an issue, you know, they hurt their back, who cares? What's that have to do with it? But drug issues are, mental health issues are. But you've got to have some kind of proof that that is going on. Or the judge is gonna go, well, it's not really an issue, you don't even have any evidence. Alcoholism,
Made for.
yeah, there would be some underlying condition that comes up, so you'd probably find that in the record. All right, let's start over, don't bring your children to the courthouse. Read everything you have filed that, or that is filed against you. Read it carefully. I have people that come to court, they've not read anything. I've seen attorneys show up in court, they haven't even read the motion that were there on the hearing. They're reading it, sitting at the desk, waiting for the judge to come in. Read things. If the judge starts talking, interrupts you, you shut up. That is respect to the judge. You may not like the judge, but you have to respect the judge. If you disrespect him to the point that he becomes, he could put you in jail. That's contempt in his courtroom. So as much as you may not want to shut up, you have to shut up. Listen. And follow his instructions. He may have good information for you, you never know. Don't interrupt him if he's talking. Do not interrupt the other party if they are testifying. Do not interrupt a witness. You have to wait your turn. And if you ask a question and you don't like their answer, you can't stop them. You open the door. You ask the question, they get the answer.
Question.
Mhm.
So I was basically railroaded in my final trial, like run over by the train because I didn't do objections and things like that when I could have.
Yeah.
So where does that fall into that line of respect and all that?
Well, you have to know, just like I told you, you're held to the same standard I am.
So just if they say a lie, say object, I object.
A lie is not
On the
the
stand.
basis for an objection. That's what I'm saying. If they lie, then when you get up there and say it, you need to say the opposite or whatever truthfully happened.
Cause he.
And you can say that he was not being
Judge even
truthful,
heard him in a lie and just let it happen. Just.
but he can testify to whatever he wants. It's what the judge decides later, based on what the judge
Because
says.
I didn't do the objections.
Well, a lie is not something you can object to. You'd have to have a witness to prove that. And a lot of times it ends up that he said, she said, and then the judge has to decide who he believes more. Did you present enough evidence even beyond the he said, she
Well,
said?
this was something silly. He had all my stuff. I got it back just recently. I mean, but he just flat out lied and then mentioned the vacuum cleaner. You know what I mean? It's like, obviously he's a liar. He got
Well,
it.
and there's
He
your
said that.
question. You just said you had the vacuum cleaner, but you also said you didn't have my stuff.
Exactly.
So which is it? When you were testifying or when you're just talking in court, you are talking to the judge. Even with an attorney, I tell my clients, because in Duval County anyway, I sit, let's say Melissa's the judge. My client's here, I'm here, the judge is here. I'm asking the questions. You're not talking to me. You're talking to the judge. I want you to look the judge in the eye, because people who don't look a judge in the eye are typically not telling the truth. So look at the judge or the magistrate. Okay, you need to do that. You're not talking to the attorney. You may ask questions of a witness, but that witness is talking to the court. They get focused on your issue. So if you're trying to divide property in dissolution of marriage case, don't run off on some tangent about, he took the coffee maker out of the house at the beginning of the divorce. But that gets frustrating for a judge. Stick to the issue. Tell the judge what your assets are, tell the judge what your debts are, tell the judge what assets you want and what debts you're willing to take on. That's what the judge needs to hear. Not that, he absconded with a coffee maker or something. Who cares? Okay, stuff is stuff. I know that sounds horrible, but it's not as important as your children, I can assure you that. That part of the case would be very simple. It's easy. Be prepared for court. So we talked about you need 3 of everything. Look at your laws. Figure out what is your burden? What do you have to tell the court to get what you want? If you're dealing with divorces, chapter 61, you can look it up on the Florida legislature website. You can see every single statute. There are free legal research apps out there you can use. You could put in, child custody, and I'm sure it will give you case law about it. See if you can find your scenario. Drug use, you could search, father uses drugs. You'll get case law. It'll give you some insight on what the judge might think is okay and what's not okay.
And my divorce case is pretty straightforward. There are no children involved, no division of property, but my partner is overseas. So those were mainly the questions that I had,
Okay.
but I did hear that you said you couldn't give legal advice.
No, I can give you legal advice. The clerks cannot give you.
Oh, I was.
Oh, no.
I was reading the note.
Is he agreeable to this divorce?
Yeah, so everything is amicable.
Okay.
And we were trying not to pay for an attorney
Okay.
because it should be just
It should be
straightforward.
very easy.
And I even have my paperwork, but because I've never done legal paperwork before, and because I know that it can be very finicky, I don't know if you can look at the paperwork today.
Well, here's what you need. You
Mhm.
need a simplified petition. You got that?
Well, I had looked at that, but I think I read because we don't want her to have to come, like, spend, money to have a plane ticket to come and everything. So I read that you couldn't file a simplified one if she's not gonna be able to be present for like the final
That's right.
hearing.
So if you, there is a consent final judgment at flcourts.org. Y'all can fill it out. You can send it overseas. He can sign it. It may need to be notarized. I'm sure, is he in the military?
No, well, first of all, it's a woman.
Okay,
And we were teachers overseas.
Okay.
And we been together for a long time, but our paths are going separate ways and such. So again, and I would have had her sign paperwork if I had felt confident about what I needed to do and what she
Right,
needed to
right.
find. And even the serving process is a bit different because it's not like someone
that
comes
is
serve her.
complicated.
So
overseas.
those are mostly the questions.
But if she's willing to accept service, you can mail her the paperwork, mail her the consent final judgment. Every country has some form of a notary, some form of a person who will say, here's your ID, you are who you are, and I'll, sign that you are who you are after you sign it.
Because
And then she sends it back. You can file it with the court. They send those kind of things to the court, the JAs. And that's simple. The judge would love to enter a divorce decree in a case like that and take it off his docket. One gone, and an easy one. But yes.
You make it sound easy.
I'll
be interested.
I'll be happy to talk to you. I'll talk to you.
Okay,
See
thank you.
what you got. Remember, if you don't appear in court, that's a problem. Talked about all that. Talked about mediation, make sure you go to the case. So let's talk about, I talked a little bit about setting a hearing versus a trial. A hearing is on a motion. Trial is on a petition, supplemental petition. I used to teach paralegals and, let me let you think about what a hamburger looks like. You got a bun on the top, you got a bun on the bottom. That top bun is a petition. Bottom bun is a final judgment. All the stuff in between, the meat, pickles, lettuce, those are motions. Those are orders that come from the court during your case. Okay? You start with your petition, you're working towards a final judgment. So all that stuff in the middle, you would have hearings on if you need them. You would have a trial on that petition and end up with a final judgment. Sorry, I'm a visual person, so. Let's see. We talked about the evidence a little bit. You would also you might need witnesses. So if you know them and they're willing to come without a subpoena, great. They just need to know when to be there. If you need to subpoena someone, I believe there is a subpoena on ethelcourts.org. Again, call them, see if they'll accept it, otherwise you're gonna have to serve them with the sheriff.
How much does that cost, just sort of?
If it's St. John, it's $40, I think. I think Duval's the same thing, and I don't know if your in-the-state application would cover that. It should, I mean, it's a waiver of fees across the board, it doesn't mean you get to go crazy if they don't bring 50 people in. Okay,
Molly, you are going to have to unmute yourself. I cannot do it for you, but go ahead and ask your question when you're ready. It looks like you're unmuted, but we cannot hear you.
Okay,
Oh, there you go.
regarding the witnesses, if they present a witness, would I be notified?
so, if it's a trial, you should be notified because there's a document called a pre-trial stipulation, which should list all your witnesses, all of their witnesses. At least you have a heads up that they're coming. If it's a hearing, maybe not. I don't file my subpoenas until after they're served. Just because if I get in front of the judge and that person doesn't show up, the judge can do an order to show cause and bring them in. Depends on how bad I need them, but. So the answer is maybe, maybe not. That's a law school answer, but, if it's a hearing, you may not know. If it's a trial, you should know. And you're entitled to call them, Molly. They should, if it's a trial, they should give you the information for that person. You can call them and ask them, why are you coming to court? What do you have to say? What do you know about the case? And they don't have to tell you, but you'd be surprised picking up the phone, people will talk.
Okay, you're saying I can call the witness directly?
Yeah, call them on the phone
Okay,
before trial.
okay. Thank
At
you.
least try anyway. All right, now, once you're in court, if you're representing yourself, you can testify. All right. You're not gonna ask yourself questions and then answer them. You're basically just gonna tell a story. That's what the judge wanna hear. In sequential order. Don't start yesterday and then talk about the first day you met each other. So tell the judge a story. Now, the other party can ask you questions. They have a right to cross-examine. So whatever you say, they can ask you about. The same goes for them. The same goes for any other witness. So if you call a witness, you can ask that witness questions. I would suggest you prepare that person so they know what they're coming to court for. You know what they're gonna say, because you might decide you don't want them to come. They don't have anything nice to say. I mean, that's true. And then the other side's gonna be able to cross-examine. So don't forget that part. People think I'm gonna bring this witnesses. They're my witness. No, the other side gets to ask questions. So get those people prepared.
Question about witnesses.
Yeah,
So what if they have memory problems? Can you just basically say, not mentally competent witnesses? Can you have them basically,
you mean their
Not-
answers
not
are,
being
I don't
French.
know, I don't know, I don't know.
well, I mean, the lady has
Dementia.
dementia. So basically, it's a manipulating thing with this person.
Well, and that's an
And so-
objection you can make if it's a leading question, if they're basically telling the witness what to answer.
yeah.
Then that's an objection, leading
Okay.
question, and the court will stop them. You can't ask those questions unless they are, this one, I don't know. Well, they're not adverse, but
I mean, can you,
they're not on your side and they become
Adversarial?
Hostile.
Hostile witness, there it is.
So can
Right.
you actually like have them discredited by saying objection, this person had memory problems, may not be able to answer questions?
Well, you can make that as a closing argument,
Okay,
that clearly this person did not have a memory enough to, recall the incident or whatever. The only way that the other side could draw questions out was using leading question. The court, I mean, your closing argument can be important.
Another question.
Okay.
You can go ahead and unmute yourself, Molly.
If they bring a family member as a witness,
Yes.
and that family member is funding their attorney, how does that affect them, or how can you bring that up to show that there is like a prejudice or that family
Well,
member is
I
willing
can
to
tell you
lobby?
judges know, if you bring your mother in, your sister in, your oldest child from another relationship, there's gonna be a bias. Judges aren't stupid. They didn't show up to testify for the other party. Now, if you wanna go down the road, you could ask if they're paying for the person's attorney, they may lie. And there's no way to prove that really. So, I mean, you can ask that question, sure.
I did see in the discovery paperwork, a family member was wiring funds to his account.
Well, if it happens often enough, it could be considered income, which is another issue. Because gifts can be income if they're given on a regular basis. Even if it's paid to an attorney.
When it exceeds a certain amount.
No, I mean, if I give you $100 every single month for the last 2 years, that's income.
It's not counted, it's like a lifetime. There's like a lifetime allowance, or is that just?
It's just a tax issue. That's just income. And a lot of people give. People that need money in their family, they give them regular gifts. That is income.
How do you prove that or get those records from like someone?
So you all have to do mandatory disclosures in cases that deal with, divorce, with child support, those kind of things. Look at the bank records. I mean, I spent a half a day yesterday going through someone's bank record. I mean, every single line. If there's a transfer from one account to another, there's gonna be 4 digits of that bank account. So now you take what they gave you, and maybe they gave you 4 bank accounts. Did they give you those accounts? If they didn't, then you can do what's called a request for production of documents and get those accounts. Now, if they're not their accounts, they should have to say that. Not in their possession, you can send an interrogatory to them, which is a written question. Why aren't these statements in your possession? Whose account is this? Give an address, identify the person, get a phone number. Then you can find out who that person is. I mean, you can go down a bunny rabbit trail real quick, but,
And also,
it might give you good information. No,
when I submit everything and he has to prove his finances, are they giving me, because I did the divorce and I remember getting the totals on, but not like his checking account. So did I just miss something at that point? When I file this, will I be able to access that information?
Yeah, if he didn't produce the documents, is what you're talking about?
He submitted the financial affidavit, but I didn't actually see like his checking account.
So there, if you look on FL courts, in addition to, the financial affidavit, there are what is called mandatory disclosure. And if you can't find them there, it's the Florida Rule of Procedure 12.285.
is it this one?
It'll give you a list of everything that has to be produced. That's it.
Yes.
Essentially, what that does is back up that financial. So if you,
I'd like to go into that. We just have a question for someone who's about to log off.
Yeah.
But yes, you can. You can get in touch with the St. Johns County Legal Aid. I would suggest you do it quick. There is a pro se class tomorrow. They might can refer you out to someone who could give you a quick call, and talk about what's going on with your case. Okay. Well, because of COVID, we don't do it live, so kind of what they do now is ship out some information forms that they fill out, or you fill out, kind of telling about your case. And they send them out to the attorneys that handle those, and we'll pick up the phone and call. I met with one today I actually met them, St. John's Legal Aid, which I prefer, but that doesn't always happen. Okay. Now, if you need an interpreter or you have some kind of disability, you can contact the court administration. And this is for the entire 7th Judicial Circuit. Because it happens a lot. The number is 386-257-6096. If you have a video or something like that you want to play in the courtroom, call the courthouse administration. They'll let you know what you might need. If you're bringing your computer, what kind of adapter you might need to plug it in so it plays on the big screen. But if you're playing those audio video, it needs to be loud enough that everybody can hear it. And if it's a video, it needs to be where everyone can see it. The call report administration, the clerks can give you that. Now, I want to give you this website because it had some really neat information about preparing for court. This is help.flcourts.gov. And then I would just search, they have a search in there, what happens in court. It even had a video, you know, it tells you what you can do, what you can't do. So it was pretty interesting. I thought it would be good. Reading material if you're trying to figure things out a little bit. Because there is a lot of information out there on the web. I know that, but some of it can be really difficult to understand. The Florida Bar also has bar articles for people who represent themselves. One's called Surviving Divorce. It was a great article. Kind of points you in the right direction for laws, for rules. Just so you know, the Florida Bar had all the rules of procedure online. You can look at those. The family law rules of procedure, they're all there. So you can look at those too. I mean, you can access just about anything you need on the web these days. Okay. Here's another one that I like a lot. It had a lot of information. See what their website. Well, it comes from the national, I'll give you the initials, NCJFCJ. That stands for National Council of Juvenile and Family Court Judges. So, I mean, it's a thick document, and this is 10 things to know about family court self-represented litigants. It's a series, so there may be a whole setup, but it had a lot of good information.
Is that a .gov one?
I don't see the website. Usually it prints on the bottom. It might have been.
.org.
Is it?
Yeah.
Okay. It probably was a PDF that I pulled up. So, do have, I only have one, and maybe I'm gonna, the clerk will make a couple copies, but or I can give you my email address. You can email me. I have a Florida evidence cheat code. So if you want it, I'll be glad to send it to you. Maybe a little outdated. This is 19, but the evidence codes don't change a whole lot every year. But just so you know, that is chapter 90 of the Florida statute. And it kind of gives you, I mean, it's not very long, and chapter 90 is huge. It might help a little bit. Okay. My email address, if you want it, is Nancy@jaxfamilylaw.biz.
I'm sorry, would you give that again?
Nancy, Nancy @jaxfamilylaw.biz. B is in boy, I is in igloo, Z is in zebra. Mhm. Now, the clerk's website, if you go on there, you can look for Judge McGillen and Judge Farabee. It'll have a place where the judges are at. Judge McGillen in particular has a whole section of procedures for his courtroom, how to get things done. Very informative. So pull them, look at them. It tells you what their unified court system is. It talks about these consent final judgments. And look, if you enter an agreement with your opposing party, let the court know. If you've got a half a day trial scheduled in 2 weeks and y'all come to a resolution, let the court know. There's a half a day that somebody's been waiting for 3 months that they might could squeeze in. Okay? So you know how it's been. You've been waiting for that trial for a long time. Give somebody else a chance. There's a lot of information about how to title, like a motion for temporary needs. All in here. I mean, he's got a lot of great information on it. And I can tell you this Jay is very kind. She won't be ugly to you. She may tell you not to communicate without the other party being there, and she may add the other party on when she sends that back. Because she's not supposed to even respond, but she probably.
It sounds like you know McGillen really well. He's actually my judge. And I was curious, do you know if he, as far as recording the court's trials, stuff like that, does he actually personally record it or does he actually just,
It's recorded through the court system, all those microphones everywhere.
Find it.
I mean, we have to be careful as attorneys if we're talking to our client during a
Yeah.
trial, it could pick up.
Oh, interesting.
So you.
Kind of like the presidential debate.
Yeah.
The statement that the judge made is not the Zoom, they said the records not there. And I'm wondering, when did they even start recording then? Because the judge said they're involved, so they were saying something else.
And if it's on Zoom, I think they record all.
Yeah, they couldn't find it. Clicked on the file, there's nothing there.
We got one more on that.
Yes. All right, you can unmute yourself, Molly, whenever you're ready.
Okay, I'm sorry, where do you find those procedures for the judges?
Oh, it's on the St. Johns County Clerk's website. Look for the judges. And then you can go down to your judge, click on them, and they should be their procedures. I just know McGillen had some really great information.
Do you know if all the judges do that or is that just something?
I don't know. Farabee didn't have a whole lot on there, but McGillen has a lot, and I would think a lot of it would transfer to Division 58, which is also a family law court. So,
If you have any questions about navigating our website, Molly, feel free to reach out to any of the contact information throughout our social media or our website for our communications team.
Thank you.
You're very welcome. All right, I think that about wraps everything up. Thank you so much for everyone who attended, participated, Nancy, of course. Our next family law workshop will be on October 2nd, same time, same place. And the registration link for anyone that wants to tune in virtually will be shared within the next week. Again, this session was recorded, so it will be uploaded in the next, say, day to our website and our social media. If anyone wants to revisit it or came in late, feel free to reach out and
We could go back and get it first session.
yes, you sure can. Yep, it is available on our website and our YouTube. Yep. All right, thank you so much, everyone, and we will see you next time.
All right.